mentioned, this is just 5 minutes of a 90-minute presentation. So bear with me here as I give just some of the highlights of updates in employment law this year. Can't possibly go into depth with all the changes, so definitely encourage you to reach out to your HR resources or employment law attorney if you have any questions about how these laws might impact you and your business. There are also should be cards on all of the tables that have just some of the specifics on some of the updates this year that hope can be helpful. But yeah, so here are just 5 of the updates that we've been getting a lot of calls about or questions about. One is that there is a minimum wage increase this year. So beginning January 1st, the new minimum wage is $16 an hour for all employers, and that translates to $66,560 a year for exempt employees. One note about exempt employees, don't think that just because you're paying the employee a salary that they're automatically exempt. That's only one of the requirements. So if you do have salaried employees you think are exempt, just double check to make sure that they meet all of their requirements under the law. There's also some different minimum wages for fast food chains and healthcare facilities. So if that applies to you, make sure to look into it and make sure you're complying with the new laws. The next is there was a mandatory paid sick leave increase. So now it's up to 5 days or 40 hours to be taken in a year. There are 2 ways you can do that. You can either do a lump sum at the beginning of the year, 12-month period, or you can do an accrual policy. There are some specific requirements if you're going to do the accrual method, which are included on that card. But if you are doing it that way, just make sure you look at all at the requirements to make sure that you are doing it appropriately. Next, there's actually a new mandatory leave. This is a 5-day leave for reproductive loss events. So this is separate and apart from paid sick leave, and it actually can be unpaid, but you are required to give employees a 5-day leave if they suffer a reproductive loss event. So that is defined pretty broadly. Reproductive loss could be, a miscarriage, or it could be failed assisted reproduction, failed adoption, surrogacy. Basically, the thing to keep in mind is if the employee would have been a parent to that child but for the loss occurring, that's a reproductive loss event. They get 5 days to be taken within 3 months of the event, and they don't have to take it all in 1 week period. They can take it, 1 day at a time, and it's something that you cannot ask them to provide notes or things, but just something to trust them that if that's something they're going through, to give them that time. The next is there's new discrimination laws that are in place this year, or anti-discrimination laws for cannabis use. So this doesn't mean you need to let your employees come to work high or be smoking in your office parking lot or anything like that. But it does require that you cannot request information from job applicants about prior cannabis use or used information about prior cannabis use that might be in show up in their criminal history. It also means you can't discriminate against employees for off-duty, not off-the-clock marijuana use. So this is just another thing to keep in mind. California has a lot of these restrictions on how you can use background checks. We've had a ban-the-box law for many years about asking applicants about their criminal history. So if your employer or you use background checks or drug testing at all as part of your hiring process or promotion process, that's something you really need to pause and double check, make sure, like I said, talk to your employment law attorney, talk to your HR resource to make sure you're complying with all of the requirements for that. And then finally, so there are some increased penalties and restrictions regarding non-compete clauses in California. So non-compete clauses have been illegal or unenforceable in California for some time now, but a lot of people don't realize that some of these might be in older contracts, or actually we do sometimes see people with them in new contracts all the time. So it's something to take a look at your form or take a look at older contracts, make sure those non-compete clauses are not in there. Also, there are some requirements now that if you have an employee who was hired, or who was employed, sorry, not hired, after January 1st, 2022, even if they're a former employee, you do have to go and notify them and say, hey, this non-compete clause is unenforceable, so that they know that that does not apply. So those are just quick updates for you in the employment law. There's lots more I couldn't get into, so definitely, like I said, reach out to your HR resource or employment law attorney.